Ms. Legalista, aka Attorney Sheila here. I'm going to be covering the Judge Traci Soderstrom case, the one where the judge sent out over 500 text messages during a murder trial. And somebody is texting me. How about that? Oh, okay. Cool, cool, cool. That's something I need to get to in just a few minutes. Let's see if I can pull up just her website really quickly. I covered her website in another video, so I'm not going to do this here, but sometimes it's helpful to have an indication of what someone looks like, familiarize yourself with someone. But this is Traci Soderstrom. She is a district court judge in Oklahoma, and there is now this complaint that has been submitted to the Office of Judicial. No, I can't remember what the name of the office is, but in any case, she is now facing this complaint about actions that she took during this murder trial. So let me pop over here onto the complaint. I'm going to scroll down to where we're going to start. We aren't going to start at the beginning because it really covers the, well, let me just show you. Okay, so this is the beginning here. We've got where we are, what I say, state of Oklahoma, filed October 10th, 2023. You see the petition here. It says she was elected. Look, she hasn't even been up there that long. I didn't even know this before. She was elected to the seat in November of 2022 and took the bench in January 9th, 2023. So she hasn't even been on the seat for a full year. And then here are the things that they are accusing her of: gross neglect of duty, gross partiality in office, oppression in office, and other grounds specified by the legislature. So these are the canons and rules, okay, that they're saying she violated. So they put those in this petition also, and you can see it just goes on and on. They made sure that they had everything in here, and then I went too fast. All right, so let's go to this first one: gross partiality in office, gross neglect of duty, oppression in office, lack of temperament for judicial office, and propriety, failure to supervise. Let's start with number 7. And this is what's going to give us some background on what was actually happening, okay, during this murder trial. Because if you have been reading about this in the news and you've heard some of it, but you now are going to have the specifics directly from this complaint. While presiding over a murder trial, beginning on June 7, 2023, the respondent exchanged over 500 text messages with her bailiff, Angela Miller, in which they mocked the physical appearance of attorneys, jurors, and witnesses, and used offensive language to deride the state's attorneys. The respondent and her bailiff called murder trial witnesses liars, admired the looks of a police officer who was testifying, disparaged the local defense bar, expressed bias in favor of the defendant, and displayed gross partiality against the state. Okay, let me stop there. So none of this, especially the last part, it's one thing to talk about someone's appearance and what they're wearing. It is entirely different to express bias in favor or against either party. You are not supposed to be doing that. There's supposed to be no partiality on the part of the judge. Respondent and her bailiff text back and forth with each other continuously during the active portions of the murder trial. Respondent placed her personal cell phone toward the front of her lap, outside the view of others in the courtroom. Respondent was scrolling Facebook, accessing various phone applications, and texting for extended periods of time during the murder trial. The bailiff, sitting in a witness box or at a small desk near the respondent, sent and received text messages during the murder trial as well. On a separate occasion, the respondent and bailiff discussed by text which jury instructions would best fit their desired outcome, not which jury instructions would fit the needs of what the jury needs to hear in order to make a decision, but what would fit their desired outcome. After publicity regarding the respondent's excessive phone use during trial, the respondent had the security camera moved where she could not be observed. When the camera was subsequently returned to its original location, a black box was inserted to block out the bottom half of the viewing area so the respondent could not be seen. The blocking was eventually removed. So she then doubled down on what she was doing wrong, is basically what this is alleging. The pattern of conduct demonstrates respondents' gross neglect of duty. Yeah, because how are you doing your duty if you're on the phone sending text messages and talking about what people are wearing as opposed to actually listening to arguments or motions or anything else that's going on. The pattern of conduct demonstrates respondents' gross neglect of duty, gross partiality, and oppression in violation of, and you see the statute there. The conduct further demonstrates respondents' lack of temperament to serve as a judge, undermining public confidence in the independence, integrity, impartiality, and competence of the judiciary. Respondents' actions giving rise to those charges appear more fully set forth in the following specific allegations. So, yeah, it truly, can undermine public confidence because number one, the public's like, well, she's not even doing her job. She's just up there texting. And number two, well, it sounds like they already had their mind made up about who should win that case. And so then again, they aren't paying attention. So those are really big problems there. All right, let's get to the case. The facts giving rise to the murder trial are that in May 2018, Christian Martzel and Judith Danker were charged in Lincoln County District Court with murder in the first degree for the death of their child. Danker entered a plea to Judge Ashwood in 2019 on an amended charge of enabling child abuse, for which she was sentenced to imprisonment for 25 years. Martzel was held in jail without bond until his jury trial began on June 7, 2023. Okay, so she's in jail, he's going to trial. The state was represented by DA Adam Panter and ADA Ryan Stevenson. The defendant, Martzel, was represented by Velia Lopez and Greg Graves, Capital Trial Counsel for Oklahoma Indigent Defense. 4 weeks prior to trial, the state filed a notice of endorsement of personal witnesses to include Dr. Ryan Brown, MD, as a witness. The defendant filed a Daubert motion. This is something they have to file for expert witnesses. The respondent did not hear the motion at a motion hearing on May 30th, 2023, and took the motion under advisement following the jury trial call docket. An ADA asked that the court rule specifically on the motion prior to the jurors being sworn and alerted the court that the timing of the ruling would determine whether the state could appeal an unfavorable decision. On June 7th, the court took up outstanding issues before voir dire, but then brought in the jury and stated that she would take up any remaining issues later. The ADA again asked that the evidentiary matters be settled before the jury was sworn, and the defense attorney agreed, saying they liked for the motions to be argued and solved so they know what they can ask and what can be said. Now, this makes perfect sense here, okay? Respondents said they would maybe take it up that afternoon when they got to the point of swearing in a panel. While the DA was addressing jurors in voir dire, respondent texts that he was sweating through his coat, to which Bailiff responded, yes, it's gross. He's gross and a horrible speaker. So let's stop here. This is this first part where we're really getting into the conversations now that they're having about this district attorney, about him sweating, calling him gross and a horrible speaker. Regarding the ADA, the respondent commented that they are going to hate him, referring to the jury as they. The bailiff responded, absolutely, he's an arrogant a-hole. The bailiff then made a crass and demeaning reference to the prosecuting attorney's wow, okay, to which the respondent replied with a haha icon. The DA made a reference to a BLT sandwich, and the bailiff remarked that the DA threw his BLT analogy back at him. The respondent replied, trash, with various emojis to the reference trash and a BLT. At no time during these exchanges did respondent admonish her bailiff not to discuss the attorney's appearing before court in such an inappropriate way. Instead, respondent joined in on the commentary by again referencing the DA's appearance and stating, why does he have baby hands? They are so weird looking. The bailiff replied, I was told they were tiny, LOL. Conversely, when the defense attorney addressed the jury during voir dire, the respondent remarked, she's awesome. The bailiff responded, yep, and she's so smart. Following voir dire, the judge sought to swear in the jurors and the state objected, again requesting a ruling on Dr. Brown's ability to testify and noting the state would lose its right to appeal and double jeopardy would attach once the jurors were sworn in. The ADA said he thought all parties agree the matters would be taken up before the jury was sworn in. The respondent overruled the state objection and swore in the jury. The Daubert hearing was held 2 days after the jury was sworn, and the respondent sustained the Daubert motion, and Dr. Brown was not allowed to testify. Now, remember, the whole point of this was they wanted to find out whether Dr. Brown was going to be able to testify so that they could appeal it within time before the jury being sworn in and all of that. All right. Paragraph 27. During opening argument, the respondent continued to praise the defense attorney by texting her bailiff, "Can I clap for her?" Now, see how inappropriate that is? Showing favoritism. Referencing the DA's office, the respondent noted they are not used to going up against competent attorneys, implicitly dismissing the capabilities of the state's attorneys and the defense bar. When the DA began to question witnesses, the bailiff texted, "He's horrible," to which the respondent replied, "True." The bailiff replied, "Sucks." While a video was played to a witness on the stand, the respondent remarked to the bailiff, "This is boring." While the interview was played, the bailiff mistakenly thought it was a video the state had previously lost. Respondent text, "They didn't lose this one, but they should have." The bailiff replied, "It doesn't help the state at all," to which respondent affirmed by texting, "No." Okay, so what you have now is their assessment, like they're assessing the evidence, they're assessing what's going on. None of this should be taking place. None of this should be taking place. Later, the respondent text, the state just couldn't accept that a mom could kill their kids, so they went after the next person available, evidencing her opinion about the defendant's innocence. So she's thinking the defendant is innocent and that the mom was the one responsible. And so how is this going to play out if you're the judge and you've already decided in your head who's guilty, who's not, which side is presenting material very well and which side isn't, which evidence should have come in and which shouldn't? I mean, very inappropriate. The respondent later texted, "This is dumb," during the state's direct examination of a witness. And her bailiff replied, "I just hope the jury doesn't buy his." The respondent commented, "He looks constipated." And is that the O look? And you can see it there. The judge and bailiff referred to the co-defendant, who was to appear as a witness, as a liar at least 3 times while she is on the stand. The respondent spent the majority of the co-defendant's testimony on her phone, texting comments like, "Can I please scream liar, liar?" This is the judge. This is the judge saying this. "Can I please scream liar, liar?" Here's the thing. Even if the judge isn't saying anything, you've got a whole jury over there who's looking at this, who sees that the judge is not paying attention, who, can pick up facial expressions, body language, all of the nonverbal communication that the judge and the bailiff are sending out into the room. The jurors who have to make a decision regarding this case are seeing all of that and they're taking it in. And this whole thing is very inappropriate. When a police officer took the stand, the respondent texted, "He's pretty. I could look at him all day," to which the bailiff replied, "Same, LOL." The respondent and bailiff also discussed whether one of the jurors is wearing a wig, with the respondent texting, "That's a wig. Look at that hairline." And later she texted, "Definitely wearing a wig," to which the bailiff responded, "Oh my God, LOL." They wondered if another witness had teeth, and the respondent texted, "No, star witness right there." Regarding another witness, the respondent questioned, "Is she blinking uncontrollably?" This is so inappropriate. Later, the respondent offered her opinion to the bailiff that DNA excluded Marzal on the bed. No way they get guilty on murder. Again, she's making an assessment about this case. During the trial, the respondent approached Sergeant Kelly Coleman, Captain Chad Pavlicic, and Detective Larry Stover in the hallway and stated that the co-defendant was not believable. She didn't think the defendant would be found guilty of murder and he would only be sentenced to credit for time served. So she's making this comment outside of judge to other parties. She granted the defendant's request for additional jury instruction for manslaughter 2, which carries a sentence of 2 to 4 years. She took the state's request for a murder 2 instruction, which is an 85% crime with a punishment of 10 years to life in prison under advisement. Okay, so let's go back and look at this for a second. So we see this. It said she granted the defendant's request for an additional jury instruction for manslaughter 2. That's 2 to 4 years. And she took the state's request for murder 2 instruction under advisement, which would have been 10 years to life. Okay, remember, she's not thinking very highly of the state. She was saying she thought the mother did it, and this just is being pinned on the guy. Okay, and so this is why this is important in terms of her mindset and what she's already thinking. If she's already thinking he's not guilty and they're going after him wrongfully, then she might be more inclined to give him less time and to not pay true attention to the facts of the case. And yeah, so again, not good. When discussing jury instructions with her bailiff, who was traveling at the time by text, the respondent notified her that we are giving an alternative instruction of second-degree manslaughter. The bailiff responded, but no, just enabling child abuse. He didn't kill that child. Okay, this is the bailiff. The respondent answered, "No, man to Fitz can't just do enabling because there is a dead person." The bailiff responded. So basically, mom taking the plea deal screwed him over. The respondent assured bailiff, "No, man two is 2 to 4 years. Enabling is 255 to life. I'd rather give the manslaughter two instruction." The bailiff responded, and he's already served that. The respondent replied, "Yeah." Okay, so see, they are figuring all of this out ahead of time, and the attorneys don't even know that that is what's going on. Like, they are deciding what they want it to be. 42. Later that day, the respondent denied state's request for murder to jury instruction, because remember, that was going to be the higher number of years, on the basis a request was made without sufficient evidence or notice. The state then requested an enabling child abuse instruction instead, and the defense objected because there was a dead body, arguing there was case law to support the objection. The defense ultimately withdrew the objection because the case law mentioned did not support their position, and the respondent then allowed the enabling child abuse instruction. The jury found the defendant guilty of manslaughter in the second degree and sentenced him to time served, a sentence only a judge can impose. Respondent accepted the verdict and imposed a sentence of 4 years, giving credit for time served, resulting in no additional jail time. After trial, the sheriff's deputy advised the DA's office that the respondent was seen using her phone throughout the trial. The DA then concluded that the respondent frequently sustained objections for facts not in evidence during his closing argument because the judge had not, in fact, heard whether the facts or reasonable inferences therefrom were in evidence because she was not paying attention. After becoming aware of a 51-minute video snippet of the trial had been publicized showing respondent's excessive amount of time on her phone, the camera was moved forward at the respondent's request to exclude her desk from view. The move left a gaping hole in the ceiling. The camera was later moved back to its original location, but a black box was inserted to block out the bottom half of the viewing area so the judge's desk could not be seen. The county commissioners then voted to remove any obstructions from the camera's viewing area, reasoning that respondent was not the only judge using that courtroom, and the other judge, Judge Mueller, did not have a problem with the original placement. While on vacation, Judge Mueller received a phone call from a courthouse employee who told her that the respondent said she either can't be trusted and or better watch her back in light of the county commissioner's decision. When the respondent testified before the Council on Judicial Complaints about these matters, she stated she was texting about things that were probably could have waited instead of recognizing that these types of communications should never be made at all. The respondent also attempted to mislead the council regarding the timing of her text messages by stating that most of the time she was texting between when a witness would come on or off or when there was a pause. Well, we just saw what was actually text, and it was not that, right? However, the timing of the messages aligned with the time on the video and shows that the texting did not occur during breaks. When asked if she recognized it was inappropriate at the time, she explained, "It was like, oh, that's funny, move on." So she totally is downplaying the significance of this. The totality of the text messages gives the appearance respondent believed the defendant was innocent and that she wanted a particular outcome in the case. That appearance and various decisions she made during the case, such as refusing to rule on the Daubert motion and denying the state's request for murder two instruction after privately expressing her personal preference for a particular jury instruction, give the appearance that the respondent may have taken actions in furtherance of that desired outcome. The respondent exhibited an absence of objectivity, and respondent's communications with the bailiff and others reflect a judge who wholly abandoned her neutral role. Respondent's public conduct referenced herein brought disrepute upon her office and diminished public confidence in the jury. And so that is where I'm going to stop. I will cover that next piece. So this first piece is enough in and of itself to just make you wonder what in the world, the comments that were being made, and this whole, and like I said before, it's one thing to comment on someone's appearance and the wigs and the teeth and all of that with the witnesses or the people who were jurors. It is another thing to decide that you like somebody else over another person. And so, therefore, as a judge, you're going to do everything in your power to have the outcome that you want instead of it being based on law. And so, this is a real problem. I have a hard time seeing how she's going to keep this seat. You let me know if you've heard about this case, you've been following this case along, and leave me your thoughts in the comments. Peace.